Good afternoon and welcome to the Supreme Court. Just want to reiterate, there's a couple rules. I know most of them have been said already, but as you are aware, please remain quiet and do not ask questions during the hearing. If for whatever reason you have to leave during the arguments, please leave out the back doors. You will not be allowed to enter until the case is over. Okay? With that, this is the last chance to silence or turn off your cell phones. You don't want to be that person if it goes off. So again, welcome to the Supreme Court. We'll get started. Thank you.
All rise. Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good afternoon to everyone, and thanks to everybody here at Papillion High for hosting the Supreme Court today. And we will start with introductions from the court. I am Mike Havican, and I am the Chief Justice. And now, by order of seniority, as to service on the court, the other members of the court will introduce themselves.
Good afternoon. I'm Lindsay Miller-Lerman.
William Castle, good afternoon.
Stephanie Stacy. Good afternoon.
Good afternoon. I am Jeff Funk.
I'm Jonathan Papik. Good afternoon.
And I'm John Freidenberg.
Very good. Thank you, members of the court. And we've got one case on the court's agenda this afternoon, and that is in re interest of Manuel C. And counsel, each side has 15 minutes to argue this morning. Is it Ms. Clabundi? Good morning to, or good afternoon to you. And Ms. Lamsky, good afternoon to you. Do either counsel have any questions before we begin? Then, Ms. Clabundi, you may approach the podium and you may proceed.
Chief Justice, Your Honors, Counsel, may it please the court, my name is Jacinta Clabundi, and I am an attorney with Legal Aid of Nebraska, and I represent the appellant, Ms. Amber S., in the case before the court this afternoon. I would like to save 2 minutes of my time for rebuttal. Your Honors, this case is about the best interest of Manuel C. and Mateo S., the children in this case. This case is also about the sovereign right of the children's tribe, the Red Lake Band of Chippewa Indians, to determine their members and lend their knowledge and expertise to the work being done in the juvenile court below on the children's behalf. The Indian Child Welfare Act, also known as ICWA, and its Nebraska counterpart were enacted to protect the best interest of Indian children and to promote the stability and security of Indian tribes and families. The best interest of Indian children is part and parcel with the compliance with ICWA. The juvenile court orders holding that ICWA and NICWA did not apply to this case and denying the Red Lake Band's request to intervene fundamentally ignore the sovereign and exclusive right of the Red Lake Band to determine its own members and is contrary to ICWA, and it is not in the best interest of the children in this case.
Has the membership status of anyone involved in this case changed since the case was briefed?
Not to my understanding. It's my understanding that the tribe has accepted and referred the children and my client, the appellant, for enrollment, but I don't believe that the official enrollment has occurred, but they still do say that my client and her children are members, as was included in their brief as well.
I think that you made reference to the some provisions in the regulations, is that right? The 25 CFR regulations as to who gets to decide.
Yes.
Could you expand on that, please?
Yes, I could. In regards to the section that you are talking about, I believe that section states that the tribe has the sovereign right and their determination that a parent or a child involved in a juvenile court proceeding is a member of that tribe and is conclusive and must be recognized by a state court, and that the tribe has the sovereign authority to determine who are members, including different classifications of membership. And once a tribe provides that information, that it has determined that the children are members, a state court must accept the tribe's determination as
So, I beg your pardon, so
conclusive.
is there some tension between the federal regulation and the state application of ICWA?
Yeah, I think there is some tension, but I believe that in the plain language of the ICWA statutes, it does not speak to any enrollment. It does not speak to them being tied together. What it speaks to is Indian members or children who are eligible for membership and the parent, and the child of a parent who is a member.
How does the tribe determine membership?
I think that every tribe determines membership differently.
What's our evidence in the record about how this tribe determines membership in this case?
I think that the evidence in the record says that, in regards to that, I'm not quite, what I would say is that the tribe determines membership. I
Because
don't
there's,
think it
you,
matters.
there's some cases where courts will say enrollment is not the only method by which someone may be a member of a tribe, because some tribes might not have roles. They have different ways of determining membership. So
And-
do we have anything in our record that tells us how this tribe determines membership?
I think in the record, they state their descendancy laws as well as other means, and I think that you can look to the record to see that. But I also think that the tribe has determined that they are members, and I think that they speak to that in their representative testifying. I also think that they speak to that in their motion to intervene, and I think they speak to that
Well,
between the
intervening, would you
correspondence.
concede that intervening alone isn't enough? There also has to be proof of membership.
I think that a tribe, I think from the actual regulations, that a tribe can relay and say that this person is a member, and then if they state that that person or child is a member, then it must be determinative. I think that the case law in it and other jurisdictions as well supports that. I think that one of the things that one of the cases is in readoption of Riffle, where the Supreme Court of Montana found that enrollment of the Indian child was not required, so long as the tribe recognized the child as a member. And they also concluded that enrollment and membership are not synonymous, and that the Turtle Mountain Band of Chippewa Indians' determination that the child was an Indian child was conclusive. And I think here it's clear what the tribe is saying. I think they are saying.
Is there a difference between membership in the tribe and membership for the purposes of ICWA?
I think that they're one and the same. I think but every single tribe has a different membership. Every single tribe is different. And if Congress intended to tie enrollment to that, then they would have put that in the statutes. But they have refused to and have not done that in hundreds of treaties with tribes. And so I think that they are leaving that sovereign part to the tribes, because they are each their own nation, their own sovereign nation, and so they get to decide that. And so I think here the tribe is saying to the lower court, and also in their appeal and their cross appeal to this court, that they consider my client, the appellant, and her children to be members. And I don't think that is disputed.
How does that square with your suggestion earlier that the membership process was still going on?
So I think that it's an enrollment process, and I don't think, like I said, enrollment and membership are not synonymous.
Didn't the tribal representative testify directly to the contrary? Wasn't the tribal representative asked, is there any difference between an enrolled member and a member? And didn't the tribal representative say, same thing?
I think that the representative also testified that they consider my client and her children to be members of the tribe for the purposes of the protections of ICWA. And I think if you look at it at the whole, that both the tribal representative's testimony, as well as the motion to intervene, as well as that correspondence between the tribe's council and the Lancaster County Deputy Attorney, as well as the cross appeal, all says, hey, overall, we believe that these people are, my client and her children are Indian members. That is what our position is, and that should be taken as determinative and conclusive, because that's what they are saying.
Is there at least the potential for more than one classification of membership within this particular tribe? In other words, is it possible that the tribe may say, yes, they're members for purposes of ICWA, but not for purposes of fill in the blank?
Yes, I do think so, and I also think that case law supports that. I believe in the Court of Appeals in the matter of NCH from the Oregon Court of Appeals. It relays that in 25 U.S. Section 1903, subsection 4, it does not distinguish between or among tribal memberships, and there's no provided plausible basis for treating one class of tribal membership differently from another, and that the ICWA does not grant courts the latitude to determine that some types of tribal membership qualify children as Indian children and others do not. And so if you have those different memberships and the tribe is saying, we have determined they're Indian members, regardless of what type of Indian member they are, as long as they are saying they are members, I believe that's determinative and conclusive under the federal statutes as well as the state ones.
Is it possible, I'm not saying on this record what it is it possible that in some tribes and in some instances, the tribe could say these children are Indian children for purposes of ICWA, but these other children are not, even though in all other respects, they might be the same?
I think that they determine their membership and they get to speak on it. And so if they made a determination that one child was an Indian member, then that is their determination. If they decided another child was not an Indian member, that is also their decision as a sovereign government.
Does the record tell us anything about when this tribe determined that these children were Indian members for purposes of ICWA?
I believe that they were Indian members as soon as the tribe found out that this case was occurring. They immediately contacted the county attorney as well as the department. I believe that they were Indian children as soon as they relayed that they are members of their tribe.
So I guess my question, though, is theoretically or hypothetically, could a tribe not recognize a particular child as an Indian child for purposes of ICWA unless and until some sort of action is filed in a state court, and then change their mind?
I don't think I've ever seen a case where they change their mind that someone is an Indian child.
So does the timing make any difference?
I am unsure on that.
All
I think that this tribe is stating that they are members, that they have a descendancy through their tribe, and that it was a separate case that caused the severance and caused them to make it so that they didn't have that connection. And they're trying to repair that connection, and they believe that my client and her children are members, and I believe that that is a conclusive determination. I believe from all of the evidence, it is clear what the tribe's position is. And so I do believe it's conclusive that it is an Indian child. And in the alternative, if there is any question if the children are Indian children, then it should go back and be reversed and remanded to conduct a further evidentiary hearing to determine if the children in this case are Indian children.
Forgive me for backing up here, and this is not mundane, I think. There's been a question, there's a challenge here to appealability of this order?
I believe so.
Could you speak to that, please?
I'm sorry, what?
Could you speak to that?
Yes, in regards
Thank
to
you.
whether this is a final appealable order, I do believe that it is. We would respectfully disagree with the state's position. We do believe that an order denying a tribe's motion to intervene is basically intertwined with the denial of ICWA. And we submit that ICWA actually creates a substantial right under state and federal law, and denying that it's applied to the case makes it so it affects my client's substantial right. And I believe that the state appellee relies on in re interest of Jasenia H., and there's a substantial difference between that case and the present one before the court. I would also state that in re Jasenia was decided before the updated federal regulations from 2016, which changed it and made it so that as soon as there's reason to know an Indian child is involved, ICWA should be applied until it is on the record decided that ICWA does not apply.
Can you cite us to any cases that would help us determine that?
I'm sorry, what?
Can you cite us to any cases that would help us determine that jurisdictional issue?
I believe that some of those cases are included in my reply brief, as well as in the amicus brief that was filed by Appleseed. I don't know if I can point to any particular cases now, but I do believe they are included in the briefs.
What's our standard of review for the district court's determination of tribal membership?
I'm unsure. I think that, again, it should be a very low bar. It shouldn't be very hard or overcomplicated to decide if a child is an Indian child. We want tribes to participate when they are Indian children. And
I guess what I'm getting at is, is the trial court owed any deference to the extent this was based on in-person testimony and possible credibility determinations?
I don't believe so. I believe that's because the federal laws also preempt this, and I believe that it is clear that the federal laws were that the tribe is supposed to be conclusive and determinative, and that the state court cannot supplant its own determination, and that is essentially what the state court is doing here. They are tying, in the order, it ties enrollment all over to membership. And that is not the case. In multiple cases that were cited in the briefs, enrollment is not synonymous. If we did so, that would make it so that all tribes are homogeneous, and they're not. They are their own governments. They get to decide who is their members, just as the United States gets to decide that.
Excuse me if you're interrupting. Let me ask you another hypothetical question. Just assuming perhaps that we did not decide with you, and we decided that enrollment was necessary, could you bring, also assuming at some point in time that mom is enrolled and so that further hurdle has been taken care of, could you bring an ICWA action at that point in time, even if the case had progressed considerably down the line?
Potentially, but I think it would go directly against tribal sovereignty to decide their membership and require that enrollment is tied to it. I think that would make it so it was extremely difficult for tribes and also create issues with challenging all of tribal enrollment. And I see I have 10 seconds left. I would like to reserve it for rebuttal.
Thank you very much. Ms. Lamsky, good afternoon to you again.
Good afternoon to you.
You may approach and you may proceed.
Chief Justice, Justices, my name is Maureen Lamsky, and I'm a Deputy County Attorney, and I'm the appellee on this matter representing Lancaster County, State of Nebraska. And in this case, I believe Justice Miller-Lehrman asked the question about whether there's been any changes. We've had numerous hearings on this in a related matter as far as that, and I believe that by the time there is an opinion issued by this court, it will likely be moot as to this case, as there will be that determination as facts have progressed. I would, though, ask that the court find that.
So are you saying the termination will have been completed at that point in time?
No, what I'm saying is that the enrollment process, the tribe's enrollment process, they've now done the genetic testing, they've had their various board meetings, and they're just waiting for one more meeting, is my understanding, that's supposed to happen in the next 30 days.
So you're suggesting this might be moot, and what ultimately are you suggesting about what this court should do?
I don't know, because normally if there's a suggestion of mootness, there's a document to file, but I don't have that at this point. I just
And that's
thought
because you're not yet in the position
to
file.
say it's moot because we don't have the enrollment documentation. I would argue, though, that the court is without jurisdiction in this matter because it's not a final appealable order. I think the lower court, the separate juvenile court, could have went on and done the TPR, and this issue could have been raised in that as far as the standard and everything there.
Aren't the denials of motions to intervene generally final appealable orders under our precedent?
Well, and then again, this is not the tribe that is appealing this. This is the mother's attorney that's appealing this
Tribe filed a cross appeal.
appeal. And then, I guess that could be, but that could have been, it still could have been addressed, because if there was error at the time of the TPR,
That's true of any intervention
Intervention.
case, though, right? The case could continue on to the end, and the intervention could be reviewed at final judgment.
Yeah, in this case, it's detrimental. The length of the appeal is detrimental and has pretty much made everything moot at this point, because for the children, and under ICWA, that is not done for the best interest of the children, as Ms. Dyke-Bundy stated. It's done for the best interest of the tribes and them wanting to protect the resources and to correct the wrong that was done.
I think
In the
she
past.
suggested it was in the best interest of tribal children.
I don't think ICWA is in the best interest of tribal children in all cases. These children, this case had been going on for an extended period of time, and there would have been the TPR already completed before the state had any clue that this was going to be ICWA, but for a continuance due to a vacation I went on.
But we
So
don't get to decide
we don't
that.
get to decide that, I know. So I don't think it is because it's upending that permanency, and as the court is well aware of, the need for permanency after, well, at this point is over 2 years, for children such as young as these children are, it's imperative. And because this is an ICWA case, well, it will be an ICWA case, it's not at this point. And the main issue that the state's position was that it wasn't an ICWA case then was because the
Well,
tribe.
what have we said about appealability from ICWA cases or ICWA issues thus far? And what is the reason why, I guess I might suggest that our appealability from juvenile cases is a little more open and lenient than in other cases?
I guess I'm not understanding what I'm
Well,
supposed to.
I asked you two questions.
Okay.
What have we said about ICWA appealability, ICWA issues, not necessarily this issue, but ICWA issues in the past? Have we said you can't appeal those at this point in the process, or have we accepted those appeals?
Well, I'm trying to think of a specific appeal right now. And the standard that mostly comes to the one is that the best interest isn't applicable in deciding whether or not to transfer an appeal, or to transfer a case to the tribe. That wasn't necessarily on intervention, so I'm not.
Brittany
Sure.
C. was a transfer case, wasn't it?
To transfer it, yes, and I know that those do get appealed, but that's usually the tribe has already intervened by the time they're asking to transfer. And this is kind of a unique situation. In the decade I've been in juvenile law, there's never been an issue or fight about whether or not it is ICWA. And the reason that there was in this case is because usually tribes will say this person is a member. But here, from the very beginning, when we'd ask if the mother was a member, it was a member for purposes of ICWA. So,
Is that a thing?
no, you're either a member or you're not. And that was what was frustrating.
Did your office change positions on this?
What, I'm sorry?
Didn't your office change positions on this case?
I don't think so. We've clearly said from the beginning, we didn't think this was ICWA. I know the court did initially make that finding, and that, I think, was just based on the form where there were no positions on that. And it just says that they were eligible, both mother and child.
Is that enough?
No,
Both
because,
eligible?
and I don't, looking more at those forms, because the question whether ICWA applies is two-pronged. The first question is the parent enrolled, or is the parent a member? And the answer to this was always no. They just wanted to extend the membership, and the Bureau of Indian Affairs and their rules, which was offered as an exhibit, clearly states that tribes, they get to determine who's their membership, but they don't get to claim children. It's their.
What's that mean?
Well, to me, it means you can't say, well, you're just going to be a member for ICWA, so we can take over this case, and then we'll figure out whether or not you're a membership later. I think this is probably the best example of a tribe trying to claim children before they've done all their own processes. And it is the tribe's determination to do their process of enrollment or their process of membership. But the state of Nebraska and these children shouldn't have to be like, well, we'll just give you ICWA determinations, and then, if the genetic testing turns out differently or something, we'll change our minds. I think they have to either say these children are members or they're not, and they wouldn't say that. They would just say, no, they're not, the mother is not enrolled, the children are not enrolled. We believe they will be eligible to be enrolled, and so we're extending ICWA to them. We're extending the protections of ICWA. And I don't think that's allowed under federal ICWA or state ICWA. I don't think their sovereignty gives them a right to extend membership for the purposes of ICWA. And that's why I think the lower court decided the decision correctly and found that ICWA did not apply at that point. ICWA is clearly prospective.
Excuse me, so I'm trying to follow the logic of that. So if the tribe's position is that the child's eligible, then treat this like a citizen member.
Well, but for the child to be eligible, you have to answer the first question, is the parent a member? And they never would say that she was never an enrolled member.
Right.
And when you asked, it was membership for purposes of ICWA, or membership, we want to extend the protections of ICWA to her. They don't get to extend ICWA. And since you couldn't get past the enrolled, it can't just be
You
a
couldn't
child.
get past it with mom, so you
So you
never
can't-
went on to children.
Yes.
Okay,
So
thank
it
you.
can't be just the child is eligible, it has to be the parent is enrolled and the child is eligible.
Your position is not that enrollment is everything, correct?
No, because I think there are different tribes that could not have enrollment, they could just say membership. The problem in this case is that they're not saying they're members of the tribe, they're saying they're members for purposes of ICWA.
And we don't have anything in our record about what the requirements of membership are.
No, and I mean, they
And
clearly.
whose burden was that?
Well, that's their burden. I think there's a case law in that that's cited in my brief that says it is their burden to prove that. And it was pretty clear that the other portions of the tribe that decide membership were still deciding that issue. But in the meantime, they just wanted to extend the benefits, and I think that was improper, and that's why ICWA does not apply at this time.
So
this
it's
case was-
evolving, right? And your position is it was a correct ruling at the time it was made?
Yes, it was definitely a correct ruling at the time it was made.
Could it be reviewed later by the juvenile court?
Well, I mean, it's a prospective determination. You can find ICWA at any point if it changes, because the tribe can change their enrollment guidelines. They've had that before where a child isn't eligible because the blood quantum isn't met, but then if the tribe meets to convene and changes the blood quantum, then 5 years later, child could be an Indian child. That's a different scenario, so it's always prospective, and then from that point going forward.
So, but in this case, the juvenile court determined ICWA did not apply, but could that juvenile court make that decision in this same case at a later time?
Well, yeah, after the enrollment process is done, or after after the tribe says, this child, Amber is a member, unequivocally without the, for purposes only of ICWA, then I think they could come back again at any time. And that's why it's not really a final appealable order, because they can come back and revisit that issue once once the mother is a member.
So
Is
if
it-
we were to find that your position is correct, it would be important that we make clear in the opinion, we're only speaking as to the determination that was previously made, and it has no preclusive effect on future changes.
So
I
that
would
gets
agree
me
with
back
that.
to at that point in time,
Yeah.
I think it was a correct ruling.
Definitely.
But if that were so, and this court were to agree, but the underlying case moves along, does termination move along?
Well, I don't know,
Is
because
this a
we-
timing, is this a timing thing?
Well, it kind of depends on what happens next. I think the court has to get jurisdiction again, and I would want to move forward, but then there's the whole issue of case transfer, what happens, which kind of makes the case tough and sad for me, but yeah, I mean, that's how it would work
So
under the
can you
current
have,
law.
is there such a thing as an ICWA determination after termination has been decided?
I think you could do that too, yes.
And what's the practical effect of that?
Well, I think there would still need to be like the cultural plan, and things like that going forward. But then that child still, I mean, the whole purpose of ICWA is to make their efforts that the child still has a relationship and,
With the
With-
tribe.
with the tribe, yeah.
Not necessarily the parent.
yeah, I mean, because you can still do a TPR on an Indian child. It's been done before.
It deals with placement, things of that nature, where you'd place the child.
But yes,
that correct?
potentially, yes, it could deal with that, yes.
So an ICWA, a determination, ICWA always applied after a termination. I'm moving along. Next steps are incorporate the cultural features and so forth.
That would likely be what would be the main thing is, yes. But I mean, that's not something that most people are against trying to do that part, but yes, that would be the next step.
But you're telling us today, as an officer of this court, that in all likelihood, by the time an opinion would come out, even an expedited opinion, there very well could be some obligation that you might have to suggest mootness.
Yeah, yes, likely. I mean, can't say that for sure, because it hasn't happened yet. It's, based on what I've been told, it's a high possibility, but I don't know. So, again, my main position is that at the time that the hearing was held, there was no, the court was correct in finding that ICWA did not apply because the tribe cannot say somebody's a member for purposes of ICWA and not be a full member. And with that, I would ask the court to affirm the lower court. Thank you.
Thank you very much. Do we have time for rebuttal?
7 seconds, Your Honor.
7 seconds. We will actually give you 2 minutes, Ms. Clabundi.
Thank you, Your Honor. I would first like to address that what the state's position is, stating that it's on the tribe and on the person trying to prove ICWA to show that it applies. I think the updated federal regulations and guidelines make it so that it is on the person objecting to the ICWA being applied to disprove that it should not apply, and they have to prove
And
due
how
diligence.
binding are those regulations on, in this case, the juvenile court?
I think the federal regulations are binding, and I think that the Court of Appeals in Nebraska has looked to the BII guidelines as something that they should take deference to. And so I do think that they've done that in court cases in the past. And so I do think that that is something that should have been applied. And I think here that there was not enough time or due diligence if there's any question. But I think that the overall what is being argued here is that if these are Indian children or not, and I think the tribe is very clear on their position in that. And I think they have done that cross appeal to show their position. I also would like to address the mootness that the state's state did mention, I do believe that even if my client and her children are officially enrolled with the tribe, that this should still be decided for, under the public interest doctrine. I think it's important to clarify that tribes' deference to them and what they are saying in regards to membership should be given full faith and credit. And so I do believe that that is something that should be done. I would also say that it is in the best interest, as I said earlier, to have ICWA apply for Indian children. Congress has stated that in the ICWA regulations that the best interest of Indian children is part and parcel with ICWA.
Before you sit down, you heard your opposing counsel suggest that the record shows that the tribe has never said that these children are members. They've merely said members for purposes of ICWA. Is that an accurate characterization of the record?
I disagree. I think the record, as stated before, the representative said that they considered them members, regardless if they said purposes of ICWA or not, they considered them members. I think that the correspondence between the tribe's council and the Lancaster County Deputy Attorney also says we consider her a member for the purposes of ICWA.
Well,
It doesn't matter the
for-
classification.
That for purposes of ICWA seems to be what your opposing counsel is saying. That's what the record is saying. Is that what the record says?
I think that it says they're members, and I again, would say that by cross-appealing, they have stated that they believe they are members.
Is there ever an assertion in the record that they are members, stop?
I think that, again, their cross-appeal makes that clear. They
Is
are
there
members.
ever an assertion in the record, evidence in the record, that they are members, full stop?
I, again, would say that she testified, and I would say that if there is any question, that should have been given more due diligence and should have been looked to and should have been, further evidence should have been presented. If there's any question, I think the federal regulations are clear that you have to do due diligence and work with the tribe to ensure that this child is an Indian child. And I don't think on the record any due diligence was done if there was any question. And I think that the order shows that that the lower court tied enrollment to every portion of ICWA. Thank you, Your Honors.
Thank you very much, counsel. That concludes arguments in re interest of Manuel C., and hence you are excused, but you can stay around. The court is now adjourned, but what we do at this point is we take questions